it please the Court, my name is Carol Wilson, and I represent Nicholas Lindsey Jr. in this appeal from his, the child's life sentence without parole after a conviction for first-degree murder. I would like to reserve 3 minutes, if I could, for rebuttal. And I would like to just argue with the Court the two issues that I believe are novel before the Court today concerning the role the parents played with the police in the waiver of the child's Miranda rights and the sentencing that is going to have to take place in this case. The first issue concerns whether the state proved that the child, who was barely 16 years old at the time, with very little experience in the criminal justice system and certainly no experience in a case of this publicity and magnitude, waived his constitutional rights before he spoke to the police. And we contend that they did not prove this and that the child did not. And the facts that are telling for this argument are that when the police, the Sergeant Skinner was the sergeant of the homicide division of the St. Pete Police Department. And he was very forthright in the motion to suppress in saying that he and DeLuca, who was also one of the lead detectives in the case, that they made a decision not to Mirandize the child when he was taken into custody at 5:15. When he was taken into custody, it wasn't just like a normal arrest where you go down and knock on a person's house or arrest somebody on the street. This was a very high publicity matter. There had been several killings of police officers in St. Petersburg. The whole community was completely rocked by Officer Crawford's death. And when Nicholas was arrested, there were helicopters flying over. There were 5 detectives alone from St. Pete, officers from DEA, federal officers, the whole neighborhood was there. When Nicholas came out of his home and was placed on the ground and handcuffed. Under that very high-profile setting begins this child's experience in this case. He was taken to the police department and isolated. And this is a very kind of fact that the Miranda case was designed to, that the reason for the Miranda rights was the kind of coercive isolation that occurs in a police station. So we don't have something like LSTAT, where the police are talking to somebody where the mom is in the kitchen and they're talking to somebody in their own home. We have a coercive police setting. And the mother actually went with Sergeant DeLuca to the police station. The police knew that Nicholas's mother was at the police station. But still, what the police decided to do was to speak to him without his mother and without giving him Miranda rights. That was their decision. And the conversation or interrogation that they had was brief. Nicholas was not admitting that anything had occurred. They asked him, had he been home that night? And he said that he was out trying to buy marijuana, and he had run when he heard the police action and lost his shoes. And then they asked about his shoes. After he was not forthcoming, they did not question him any further. And those statements that he made at that point were suppressed by the trial court. So then, after the police have decided not to read him Miranda, to continue to isolate him from his mother, they place him alone in a room where he remains for several hours. In the meantime, what the police do is they make the parents witnesses against their own child. And this is a crucial fact in this case, because then the parents are no longer just parents. When they are united with their child, they are not simply there, as a parent would be, to give support, possibly advice to the best of their ability. They are there to get their child to talk.
Were they aware that they were being recorded?
When they were speaking, there's nothing in this record that indicates to me that they knew that was happening.
And were they being observed?
They were being observed.
And were the parents aware of that?
No, I don't believe so. The reason I say the parents were witnesses is that the detectives, after they left Nicholas, went to the mother and talked to her about the sandal, had her sign a picture of the shoe, saying that she said this was Nicholas's shoe. She signed and dated that. They obtained evidence from the father where he admitted to one of the detectives that the Urban Flats video, which was a picture of someone in the area an hour and a half before the shooting, that was on camera, street camera, the father said that that looks like my son. So you have the parents now are witnesses identifying their own child in various ways, who have repeatedly said to the police, and this is what Skinner, the sergeant, the head of the whole department, said, while speaking with them, the parents, they kept saying, let us talk to him. He'll tell us the truth. He'll tell us the truth. Or we'll know he's lying or not. Let us talk to him. So the police knew. This is what the parents wanted to see their child for. They wanted to get him to talk to the police. Then Skinner continues, I basically conversed with another detective and didn't think it was a bad idea. So we just put them together and basically just monitored their conversation. So in this way, this sets up the videotape, which I hope the court will view before they make a decision in this case, because it's very different from the cold transcript. And when you see the videotape, the extreme measures that the parents use to get their child to talk, which in a parent-child situation might for them be common, but in the context of a child waiving his constitutional rights, it's a completely other matter. The parents are not lawyers, and the constitutional right is not to have your relatives there, it's to have a lawyer there. And the reason for that is because lawyers understand what's at stake and can actually give legal advice. Parents are there to provide support for a child, but they were not there in a supportive role. The police knew they weren't there for a supportive role because they told the police, we will get him to tell the truth. We will get him to talk. We will get him to waive his Fifth Amendment right. And they proceeded then to tell Nicholas, if you want to come home, you have to talk. They have your clothes, they have DNA, they have a video. They will try to kill you. They will hang you, they will put you in the electric chair.
Basically what an officer would have told him in an interrogation.
The officer would not have been permitted to tell them that in an interrogation. That would have been deemed coercive under the case law. So the parents, in their ignorance, were doing things that the police would not be permitted to do. And the police sat back and watched. The parents told Nicholas that the whole family was being dragged down by the police. The police were there at their relative's house, trying to get statements, trying to get evidence, and that he needed to talk to the police in order to alleviate the pressure on the family.
Under Coolidge versus New Hampshire, in order to determine whether the parents were a state agent, there's at least two prongs that you have to show. The second prong is whether the individual intended to assist to the police or to further his own ends. And the argument that the trial court found, and there seems to be evidence, is that the parents kept saying repeatedly to the child, we can help you, we'll go back to the house, we'll make phone calls, we'll do what we have to, but you have to tell us the truth, which suggests that there's evidence to support the trial court's conclusion that the second prong of that test was not made. They weren't there to benefit, collaterally perhaps, the law enforcement, but they were there for their own ends. What is your counterposition?
Well, exactly what I was just reading to Your Honor, that they told Nicholas that the family was being pressured by the police, and that was why they were there. He said, Nicholas, you have to tell the police because they're at your auntie, several different aunties and grandmothers. They're at your grandmother's house. So they're there to relieve the family pressure.
Well, what they told him isn't necessarily the test, is it?
Well, if you're going to determine...
If the issue is, are they attempting to get him to talk? Whatever they say to him is really, aimed at that, is it not?
Right. Their goal is to get their
So
child to talk.
They've said to the police, we will get him to talk. And they can walk in there and they can say, we'll pay you $1 million if you talk. They can say whatever they want to say, whatever they say to get him to talk. Getting him to talk was the object.
That was the object. And the point here is whether the child validly waived and knew what he was waiving. And when you get to the part of the video where you see the police are in the room with Nicholas, it's a very emotional time.
You're about 10 minutes in. Do you want to talk about the...
Thank you, Your Honor. I appreciate that. I do want to talk about the sentencing. Counsel and I were just discussing prior to the argument that we both viewed the oral argument before the Florida Supreme Court in Horsley and Falcon, and that in light of this court's decision in Rodriguez, I'll mispronounce this, but Di Guzielli, this matter would have to be remanded for resentencing. And our position then is under State versus Fleming that the law that would apply at the time then would be the new law that has just gone into effect as of July 1st. Under that sentencing scheme, Nicholas would be entitled to another hearing because I don't believe this hearing that was held was scrutinized in the proper way according to the trial court's order. And I have laid out numerous factors that I think were erroneously applied. And I would suggest to this court that this is an opportunity because there are going to be many of these hearings because of the predilection that courts have for sentencing children to life. There are going to be many of these hearings, and if you could give guidance to how these factors could be applied, this case would be truly a good opportunity for the court to do that. The trial court did give an exhaustive hearing, and the defense was able to present quite a bit of evidence. The state chose not to. So just the question of who bears the burden in applying these factors would be extraordinarily useful because we contend that the defense was put in the position of having to prove why the child should not get life, and that is not constitutionally the appropriate place when the state is seeking the ultimate penalty against the child. The factors that were used in this case for sentencing that were inappropriate I've detailed in my brief, and I would be happy to answer any questions that you might have about any of those factors.
With regard to the sentencing, the trial court's order at the very end, I think, recites a number of statutes that would support life, one of which is 1020. I don't remember the number off the top of my head.
Right.
If for analytical purposes, the Miller-Graham portion is invalid, but the trial court is correct under 1020 life, since that's discretionary, and imposing a life sentence. If the trial court is correct on the secondary basis, is that a requirement for us to affirm?
No, because under Starks and the cases that the state cited in their brief, all of those cases involve an underlying felony for which the penalty is less than life. There's no first-degree murder case, and you don't have 1020 life in a vacuum. That's the problem.
Felony murder too.
Right. You would have to have an underlying crime, and so in these first-degree murder cases, I don't think that 1020 life really saves the sentence. Or if it did, he would still have to be resentenced with knowing that that's discretionary.
It strikes me that after reading Graham and Miller, that the only change that the Supreme Court would have to make to its analysis, assuming the majority stays intact, is to delete the word mandatory. And basically any time, and basically articulate a rule that says any time you're going to impose life without parole, you have to have this hearing to consider all these factors. I think that's about the only word they have to change, because everything else has been a mandatory non-homicide or a mandatory. And this would now allow trial courts around the nation under a sentencing guideline to basically ignore that and move to impose life without any hearing. So I would guess that if they stayed intact, that would be the next area of constitutional litigation.
Exactly, and in light of the language in Miller that says this should be an unusual penalty, if that sheds any light on what the future is, then certainly I think that it would be wise to follow what the legislature did in the sentencing scheme and implying these factors, and we would ask this court to give us guidance on how those should be applied in this case and in the future. And if With the court's permission, I would reserve the rest of my time for
You have
rebuttal.
5 minutes.
Thank you.
Good morning. May it please the court. I'm Suzanne Bichard, representing the state of Florida in this case. To address the issues that have been addressed already this morning, just to talk about the first issue with regard to appellant's waiver of his Miranda rights. It's the state's position that law enforcement did not unconstitutionally delay in administering these rights in a circumstance that the courts condemned in Ross and from the Florida Supreme Court and Siebert from the United States Supreme Court. And I think the Ross case is very instructive in this matter. When you look at the facts of the Ross case, that was a situation where officers deliberately chose not to administer Miranda warnings prior to questioning the defendant for hours of intense and highly accusatorial questioning. In that circumstance, the Siebert...
Including the sheriff, right?
Pardon me?
Including the sheriff.
Yes, Your Honor. Yes, Your Honor. And they had lots of information, lots of evidence against Ross. They hammered him about it for hours and hours. And then afterward, after they'd been doing this for a long time, then they minimized the Miranda warnings themselves by saying, well, we've got to do this, or words to that effect. That's not what happened in this case. What happened in this case is there's no doubt that appellant was in custody. And there's no doubt that he was 16 years old. There's also no doubt that he'd had quite a bit of experience in the criminal justice system already, or at least the juvenile justice system already. He had, in fact, been administered Miranda on 3 prior occasions and had waived his Miranda rights. So appellant is brought in. It's roughly around 6 o'clock. The testimony is that they talked to him for about 20 minutes, starting at around 6:30. And at around 6:50 they were done. They didn't consider it anything more than just a kind of getting to know you sort of thing. They didn't administer Miranda warnings at that time. They didn't talk to him about the facts of this case. They asked him apparently something to the effect of, were you out last night, and why do your shoes not fit you, or something like that. And he said he was out, and that he lost his shoes, his flip-flops, when he was running away after he heard police activity. And the trial court did suppress those statements. Now, we get to several hours later. Remember, they leave him in the room. They've got him monitored, but they're not talking to him about anything. I think there was testimony that, one of the officers talked to him about football or something like that. So they're not questioning him. They're not interrogating him for all this time. What they're doing is they are processing lots and lots more incoming information about the murder. And in the meantime, they also speak to the parents. And they talk to the parents. The mom already has her suspicions, it's clear. They talk to the parents. They let them in on some of the information that they do have. And then the parents do say, let us talk to him. We can get him to tell the truth. Now,
So at that point,
pardon me?
so the police say, okay, and send them in there, and they still haven't Mirandized him.
Exactly.
So basically, they got the parents prepping him to not invoke his rights when they do Mirandize him.
Well, and again,
Isn't that a fair characterization of what happened?
I think that, let's look at I think it's the Coolidge case where we talk about the factors. The first factor is whether the government was aware of and acquiesced in the conduct. I don't really think that we can argue that they weren't aware. That's what the parents said.
That's what the parents said they were going to do.
But where we get to the issue here is the second factor, whether the individual who was, talking to the person intended to assist the police or further his own ends. Now, in this situation, and again, do look at the tape, and I'm sure that you will. You look at it, it is a highly emotional situation.
But again, what they say to Nicholas is really not the test of what
I understand what you're saying, Your Honor. I understand that when they're saying,
we
want to help
you,
we want to help you, we can't help you unless you tell the truth. But look at what they do say. What the mother says almost immediately is, was it an accident? So she's suggesting, was it an accident? And then he comes up with this fairly elaborate story about Javaris. And he makes up this story about Javaris. The parents are extremely relieved. It's the state's position that the fact that he was able to make up this, this story to tell his parents shows that his will was not overborne. They wanted him to, they really were interested in having him exonerate himself.
But never once did they say, gee, you should call a lawyer before you talk to the police. I mean, they were urging him to talk to the, we'll get you a lawyer, but they're urging him to talk.
I understand, Your Honor.
And we'll get you a lawyer, I assume, to defend whatever comes down the road, but you need to talk to the police, and this is...
I understand what you're saying, Your Honor, but again, that factor in Coolidge is, were they looking to further their own ends? And it's the state's position that they were looking to further their own ends. They thought that Nicholas would be able to lessen his responsibility in some way or exonerate himself. They already knew that law enforcement had evidence against Nicholas, but it's the state's position that their goal here was to get him to talk to police because they thought that he could lessen his own responsibility or exonerate himself. And when he said it was Javaris,
Before that, he says that to them. They have no basis for thinking there was somebody else.
Well, they didn't have any basis for not thinking there was somebody else.
The only information they have is that it was him.
Possibly.
The mom has suspected and asked him.
And he denied it.
Right.
And he denied it. And then one of the first things that mom suggests when she gets in there with him is, was it an accident? So it's clear that they're looking from the get-go to have him exonerate himself in some way or to lessen his responsibility. And that second factor in Coolidge is, did the individual want to assist the police or further their own ends?
Well, so let's come back to that. They are trying to get him to speak to the police.
Correct.
Whatever he says.
They want him to, and let's look at what...
I mean, what I'm saying is that if they want ultimately him to either be exonerated or, lessen the consequences that he's going to face, is one thing, and you can look at it at that level. But the specific object of this meeting is to get him to talk and to the police, and in that sense, can it be argued that whatever ultimately may happen down the road, they were attempting to assist the police
for their own ends? And I don't, I would urge the court not to veer from, the language in Coolidge, which talks about what is the reason why the person wanted the suspect to talk to the police. They, in the state's opinion, clearly wanted him to talk to police because they thought it would do him good. And when you look at the facts of the Coolidge case, where I think that was the situation where the wife brought out the guns and the clothing, she did this because she thought that, they had nothing to hide and that her husband was not involved, or that the physical evidence that she gave them would help exonerate him. And I think there's an analogy to be drawn here in that, the mom and dad, and in fact, Dad, the first thing he says when he walks out of that room is, he gave us the name. He gave us the name of the person who shot your officer. And I think it's very important when you look at the entire context of this, and you look at these factors that the court talked about in Coolidge, that, mom and dad wanted Nicholas to talk to the officers because they thought that it would help exonerate him or lessen his burden. And
in the beginning part of the discussion with the parents, he maintained steadfastly that he wasn't there and he doesn't know anything about it.
That's correct.
And the parents begin to leave the room, if I recall correctly. And I couldn't quite hear everything, but then they come back. It's almost as though the conversation ended when he said, okay, if there's nothing more for us to say, you didn't do it, that's the position, we're leaving the room. Father gets through the door, almost through the door, if I recall correctly, and then they come back, embrace, and the door stays open from that particular time, which I thought was unusual, but the door stays open because it obstructs part of the view of him in that corner. And then you would go through that rest of that dialogue about, tell us about it, stop sniffling, you got to tell us. For us to help you, you have to tell us. So, I mean, what is your view of that stop? Does it have anything? It's just part of the continuum of time?
I think that the entire thing was fairly brief. I don't think that, I mean, I really didn't pick up that to the extent that I gave it any significance in the context of this. I think what is significant to me is that, you know, yes, it was an emotional situation, but that the mother almost from the outset suggests, was it an accident? And then, you know, he continues to maintain he wasn't there, and then he comes up with this fictitious real shooter, and they are very pleased, or not pleased, but they are very relieved about that, and that's when they say, okay, well, you need to tell this to the police. And that again points straight to that second factor in Coolidge, that they were doing this to further their own ends.
Okay. Let me ask you this. Would we, if we were going to rule for the defendant on this, which, you know, highly speculative at this point, but would we necessarily have to conclude that the parents met the Coolidge test to be agents of the police? Or could we find that the waiver of Miranda was accomplished by a coercive circumstance that the police encouraged? Because the parents said, we will get him to talk. And the police send them in there to get him to talk, and again, and they are, as Ms. Wilson points out, using pretty coercive arguments to him to speak. Do they really have to be police agents, or can we conclude that simply the police knew this was going to happen and allowed it to happen in order to get him to talk?
Well, I don't think that the court, I think that you can look at the entire circumstance of this situation, and you look...
And conclude that it was not a voluntary, because
and
Coolidge is a Fourth Amendment, go into the house and get the stuff, and that's a different circumstance.
I understand. I understand, but I think, the factors that you take into consideration under this circumstance include, I mean, yes, he was 16 years of age, but he had some pretty extensive... He had had run-ins with the law before. He had been administered Miranda 3 times in the past.
These are not the police there asking him to speak. These are the parents.
Well, when he ultimately waives his Miranda rights, he does. They administer Miranda. They did not downplay Miranda.
But by then, he's been kind of pounded like a blank steak by his parents to talk to the cops.
Well, I think you have to look at this entire situation in the context of the whole thing. And you have to take into consideration, I do believe you have to take into consideration the Coolidge factors, and then, he's in there.
Well, that was my question. Do we actually have to consider the Coolidge factors? Do we have to actually decide that the parents were agents of the police, or can we conclude that the coercive situation created by sending the parents in there knowing what they were going to do is undermine the voluntariness of the waiver?
Well, it's the state's position that it did not, of course.
Of course.
But I think, you would need to look at all these other circumstances involved with this individual in order to determine whether or not this was a coercive, that his will was overborne. Right. And you've got this young man who is...
So it wouldn't really be necessary if we considered all of those circumstances, it wouldn't be necessary to conclude that the parents were agents of the police.
If I understand your question correctly, you're
asking... What I'm saying is that the Coolidge test is, is somebody acting as an agent of the authorities. And in Coolidge, that was a, search and seizure issue, really.
Understood. Uh-huh.
This is, was there a voluntary waiver of Miranda rights? And the police, knowing that the parents were going to go in there and urge him and, as I say, get him to speak, do we have to conclude that they were police agents, or can we simply observe that fact as one of the coercive factors?
Well, okay, and again, if you've got to look at this in the entire context of it. He is in there with his parents. They are urging him to speak, and it's clear that they think that he can speak and help exonerate himself or lessen his burden. And he makes up a story about how it was Javaris who did this, and he tells the entire... So it's the state's position that this story that he makes up, in this, what's claimed to be a terribly, horribly coercive situation, he gives them a story about Javaris Young, and he says, he gives all the details. I rode up there, Javaris was driving, I get out and I'm going to pop this car, and then the cops come and I see them and I run, and then I hear gunshots after I jump over the fence. So it's the state's position that the fact that he's able to come up with this pretty elaborate story about Javaris, who doesn't really exist apparently, suggests that his will was not overborne. And then you come into
I don't want you to get away without talking about the sentencing. And you're down to about 5. We've helped you use your time, or I have, but you're down to about 5 minutes.
Well, as far as the sentencing situation is concerned, obviously, with regard to the claim under the statute, itself, the Florida Supreme.
Statute.
Pardon me?
The new statute.
The murder statute, is sentencing of life under first-degree murder. Obviously, that's an issue that's before the Florida Supreme Court. The trial court in this case did hold a hearing pursuant to Miller, and the factors were presented, or the factors were dealt with, and the court considered all those factors. The state.
The tenor of the order did seem to suggest that the judge was viewing this as an opportunity to give the defense, an occasion to give the defense an opportunity to prove some sort of exception to the mandatory life, or life without parole. And do you think that was the appropriate burden?
Well, I don't. Under these circumstances, again, we're dealing with something that is unfamiliar territory for everybody.
We're out there beyond the edge of the earth.
We are. And at that point, we had he got sentenced under the statute after his trial, and then I think it was maybe 6 weeks later that Miranda came down, and we had the 3800 hearing, and I think that the trial court handled it appropriately under the circumstances because
well, I'm not suggesting the trial court didn't do a good job, but I am suggesting that maybe the judge viewed what the dynamic there was supposed to be under Miller incorrectly, and this is quarterbacking later after the
Of course, and I don't, under the circumstances of this case, I don't really think that given the facts and the factors that the court considered in its order, I don't think that the ruling would be any different, no matter whether the court said, whose burden we're dealing with here. I think that given the facts that the court found to be significant in deciding that a life sentence was appropriate, I don't think that's going to change, no matter who had the burden or is perceived to have the burden. But I think under any circumstances, we're ultimately going to get guidance from the Florida Supreme Court through the Horsley and, Falcon, but more so Horsley decisions.
And maybe Rodriguez.
We shall see.
Maybe by cert we'll go one step further.
Pardon me?
By cert we might get one step further.
Perhaps.
And maybe in Lindsey. No.
Maybe Lindsey, maybe, we just don't know.
I do have a question on the trial judge's order. When he talks about the studies, and perhaps I have misread Miller, my reading of Miller suggests that those studies that the majority relied on, first in Graham with Justice Kennedy and then Miller with Justice Kagan, became the underlying girding, saying that juveniles as a matter are different. They have less ability for impulse restraint. And it looks as though the trial court is saying, now you have to prove a linkage to that. The way I read those opinions was, because of these studies we find this to be true, this is now a categorical rule, which if that is correct, then that would suggest that the trial court's application of that part of its analysis may not be exactly consistent with the opinion, because I don't think the opinion requires you to prove the studies. It is like a given, because the Supreme Court says we now create a categorical rule.
Well, I think, again, we're working without a whole lot of guidance.
The judge worked now than that when he did it, but I'm just saying.
I understand.
We got here now.
I understand, but in this situation, we had the doctor who had examined Mr. Lindsey, and he's examining him with a view toward these factors, and he testifies that those studies were the underpinning of the court's rationale in Miller. So I mean, again, I think that under all these circumstances, I don't believe that the outcome of this would have been any different. The court considered all those factors, and it also considered the unique facts of this case, and ultimately concluded that under this circumstance, a life sentence was appropriate under the statute. And also, you know, the other prong of our argument here is that the 1020 life statute, 775.0A7, 2A3, it says the convicted person shall be sentenced to a minimum term of 25 years and not more than a term of imprisonment of life in prison. And that does not run afoul of the decision in Miller, because Miller was fairly narrow. It said that you can't have a mandatory life sentence when somebody's a juvenile. And under that sentencing scheme, it's not a mandatory life sentence. The court had discretion to make a determination of whether to sentence him anywhere between 25 years and life.
So would you take the position that this is a legal sentence because under 1020 life it's not mandatory, and
Yes, Your Honor.
The court held this hearing and considered all these factors and that was his conclusion?
Yes, Your Honor.
So there's nothing wrong with the sentence?
No, Your Honor.
Because of 1020 life?
Correct. If there are no further questions, we would ask the court to affirm.
Okay, thank you much.
Nicholas was 14 years old, and he had 3 run-ins with the police that took him through the juvenile justice system. There's nothing in this record that shows he ever had any experience with a lawyer, which places him as a very different kind of kid compared to the kid in Benjamin case, which is the Mississippi Supreme Court case, which found that the use of the mom undermined the waiver of that child's Miranda right, when that child was at least knowledgeable enough to ask for his juvenile lawyer. So you have the state says he's got quite a bit of experience. He's never been in this situation before.
Was he read Miranda before?
He was read Miranda when he was 14.
3 times?
I've had 3 teenagers. If I asked them what they did 18 months ago and if they could remember it, they're highly intelligent. I'd be very surprised.
On 3 occasions was he read Miranda previous to this incident?
He was either read it or given a form.
And he was offered Miranda in this case. That's not in dispute, right?
That's not in dispute. The question this case presents is, under the totality of the circumstances, did this child waive his Miranda rights?
Getting to Judge Northcutt's inquiry, do you believe that this case rises or falls on the Coolidge test?
No, I do not, because there's been so much case law. First of all, there's Miranda, and then we have all the cases about Miranda waiver. And even the Ross and Ramirez case from Florida Supreme Court, they show it's the totality of the circumstances. And that's what this court has to look at. It's not what the parents thought. It's not what the police thought. It's whether the state has a dual role here. They want to get a confession, but they have to get a valid waiver. And they have to do that. And if they don't get the valid waiver, then what they get is not going to be admissible. And that's what happened in this case.
Well, is there anything about the parents' involvement that would suggest that they were doing anything other than trying to make the best of the situation on behalf of this young man?
This is a very high-profile case, and everybody was under a lot of pressure.
Sure.
This was not like the mother in the kitchen in Elstad. These parents were terrified. Were they terrified for their child? I'm sure they were. They told him in the video, "You can die." They thought their child would die. They were they thought their child had to speak to the police or he would die.
Is it a fair interpretation that they were trying to get him to cooperate to avoid
his death?
The worst.
Right. In
order to his benefit.
Well, that may be true. That may be what.
That really goes to the Coolidge test about whether they were agents. That really doesn't address whether their participation in this whole series of events was coercive.
Well, I think it actually shows it was coercive. I mean, if I wanted anybody to coerce me, just put my 88-year-old parents in the room with me.
Yeah, but what I'm saying is that what their motive was has no bearing on that. What their behavior or conduct was toward their son would.
Right. And I think that their behavior, which we can fortunately see, and this court can give greater deference to that video however you do, because you can look at the video. We're not just reading a cold record here. And our position is that that is coercive.
Now, the officers could have read him Miranda and interrogated him without the parents being present.
They could have done that from the outset. They could have done that from the very beginning, but they made a different choice.
Right.
They made a different choice for whatever reasons. I would say they did it because...
that it would be more beneficial to him to let him talk to his parents before...
Well, they could have let him talk to his mother. She was at the station. They didn't let that happen. They made choices to isolate this child and not give him his rights.
If this was coercive, as you suggest, how do we factor in the fact that all this coercion that the parents applied resulted in a false story? The truth didn't come out, arguably, until after he read the Miranda warnings were read to him. And they asked him the question, can you read the last question out loud to us, which was, knowing these rights, do you wish to sign it? And then write your answer and tell us what your answer is when it turns out to be yes. So if it was coercive, it only coerced him into lying, right?
No, it coerced him into placing himself and giving details that were crucial. Because at the end, when he was confronted with Ashton Ware, with the person that was there during the shooting, that's when he said, everything I said is true except take Javaris out of it.
In neither case did he ask for a lawyer.
He didn't ask for a lawyer. He didn't know what a lawyer was. His parents said, we will get you a lawyer. He doesn't understand what that means.
Okay, Ms. Wilson, you're at the end of your time.
My time is finished. I appreciate this court's time. I do believe that Miller was not accurately applied, the science in Miller that Judge Casanueva mentioned, and that there should be a reversal of the judgment and resentencing, if not a reversal of the judgment. Thank you.
Thank you both very much. Well argued. Tragic.
Difficult case.